In considering the special problems posed by public welfare offenses, it may be helpful to reach back to the early days of this course and consider some of the constitutional limits concerning fault. Recall that Section 7 of the Charter states that one has a right not to be deprived of life, liberty, or security of the person, except in accordance with principles of fundamental justice. Now, one principle of fundamental justice, of course, is that a person cannot be convicted without fault. This is a principle established in BC motor vehicle reference, a case which in turn was the springboard for the argument in Martineau that the offense of murder as a constitutional matter requires at minimum subjective foresight of death. And it was also the springboard for the observation in Beattie that true crimes generally require at minimum proof of a marked departure from the norm. It follows from this that an offense punishable with imprisonment, presenting even the risk of imprisonment, say for the non-payment of a fine, must have some sort of fault requirement. Moreover, recall as well from the early days of the course that there is a presumption of constitutionality. In the absence of express language or necessary implication, we are to construe statutory provisions in such a way that they will be constitutional. If, having gone through the usual techniques of statutory interpretation, there are two readings available to us, we should prefer the constitutional reading, even if that means stretching the text to some extent. Well, the upshot of all of this is that if a public welfare offense is punishable with imprisonment, such that Section 7 of the Charter is engaged, there is an effective presumption that it is not an offense of absolute liability. And this will therefore pull in favor of a reading of the offense in question as an offense of strict liability. By contrast, it would appear that the presumption of constitutionality has nothing to say where an offense is punishable solely with a fine, even, it would appear, with a very large fine.
You may have noticed there that I was wearing a high-visibility jacket.
Very good reason for this. It's because the French recently and very quietly introduced a law saying you've got to have one of these in your car at all times. Maybe we should introduce a law saying that you've got to have onions in the boot of your car. Don't announce it and then just fine every Frenchist who arrives in Dover without any.
Furthermore, there is another lingering question. The Supreme Court of Canada recognized the halfway house of strict liability before the Charter was created. After the BC motor vehicle reference holding that it is a principle of fundamental justice that there can be no conviction without fault, the question arose whether strict liability could be constitutionally sufficient. Why is this a question? Well, on one hand, because strict liability is a form of objective fault, which at the time was regarded as constitutionally suspect. But also because of that reverse onus that the defendant bears to establish due diligence. Now, implicitly, the Supreme Court of Canada in wholesale travel rejected the suggestion that strict liability is unconstitutional. We know, of course, from cases like Creighton, Hundal, and Beattie, that the mere fact that an offense is essentially one of objective fault is not in itself a problem. But what about the reverse onus? Surely this poses problems under Section 11D of the Charter. Well, here, the Supreme Court in wholesale travel was wildly split. Two judges of the court said that for regulatory offenses, Section 11D was not infringed by the reverse onus, meaning that there was, in effect, no need even for the state to justify it. By contrast, 7 judges on the court said that the reverse onus was in need of justification. But of those 7, 3 members of the court seemed to suggest that it would be relatively easy to justify infringements of Section 11D in the regulatory context. Now, in wholesale travel, there was a statutory defense available to the defendant, but one that was narrower than the Sault Ste. Marie due diligence defense. On this basis, the Supreme Court struck it down, replacing it, in effect, with the Sault Ste. Marie due diligence defense. In effect, then, the Sault Ste. Marie due diligence defense has come to seem like the constitutional minimum for public welfare offenses in which there is a possibility of imprisonment.